SJC-13688 and Weiss et al. Versus President and Fellows of Harvard College et al.
Okay, Attorney Catalano, whenever you're ready.
Just a moment, Your Honor.
Of course.
Chief Justice. Good morning, Chief Justice Budd, Associate Justices. May it please the Court, Jeffrey Catalano for the plaintiff appellants. This is obviously a case of great public interest and policy importance involving a potentially uniform application of a law across the country. It is with that context and for the four following reasons that the trial court's order must be reversed and this case remanded back. First, dismissal on a 12b-6 was inappropriate because the plaintiffs were unfairly denied discovery and the opportunity to further develop facts alleged in their complaint, facts that plausibly suggest a lack of good faith by Harvard arising from the abhorrent conduct in Harvard's own morgue by Harvard's full-time employee, morgue manager, Cedric Lodge, conduct that was persistent and repeated over 5 years. Second, the plain language of the UAGA and its development through its history demonstrates that it applies to the donative process or the transactional aspects of the donation, as we've called it, and not to the disposition of the body. Simply stated, it is silent with regard to anything related to what happens in the morgue, handling the body, tracking the body, labeling the body, preserving the body, or securing the body. The facts here involve a different stage of the anatomical gift process, which the UAGA simply does not address. Third, however, if the court were to determine that the UAGA does apply to this conduct, then the undeniable, admitted bad faith of its own morgue manager, Cedric Lodge, over many years, is imputed to Harvard itself under the UAGA. As this court in Carey versus New England Organ Bank and every other court that's looked at this issue of good faith or bad faith under the UAGA has determined, it is the conduct of the individual at issue, the employee, whether it be an organ bank or a hospital, that is looked at to determine if the institution itself, as was the case in Carey, did or did not commit bad faith. No court has looked at the issue of good faith under the UAGA and grafted onto it a vicarious liability determination, which we argue respectfully the trial court erroneously did. Finally, application of the immunity for this conduct would run counter to the intent of the UAGA to encourage and facilitate anatomical gifts. It would discourage donations if there is no institutional accountability for anything that may happen, any desecration of the body prior to its disposition. Now, if I may, I'd like to first expand on why.
Go to the plain language one first, as opposed to the discovery for a second. So there is language, right? There is language that address this, right? It's permissive language about allowing cremation, burial. So it's not as if it's not addressed. It's not silent, right?
It's silent with regard to the specific activities that would be related to the disposition. And the language you're referring to,
well, but it's clearly dealing with the end of the process, right? It's saying, it's incorporating the end directly. It's not directing exactly how you do it because the family may not want to do these things, but it is addressing it.
We argue that to the extent it addresses it, it addresses it in the context of a procurement organization, and in terms of how it's read.
Is that right too? Because I thought that when you read the exact language, I'm just looking at it. Subject to the terms of the document in this chapter, a person who accepts an anatomical gift of an entire body, that's a medical school, right? May allow embalming, burial, or cremation and the use of remains in the funeral service.
A few things about that, Your Honor. First, that section is within an entire, that sentence is within an entire section dealing with only procurement organizations. Now, to the extent that that could be interpreted to apply to a medical school, when there's nothing within the actual section or even the comments that suggest it may, to the extent it can be, what it really is referring to is that the medical school may allow for cremation, burial, or funeral. We are not arguing that Harvard did not allow for that.
But doesn't necessarily entail storage and proper security?
I don't believe so, Your Honor, because if
Because
there
we
was...
have the medical purposes, or the scientific purposes, then we have the disposition of the body after that, correct?
Correct.
Both in the statute.
Yes.
In between those two events, there's storage and proper security, correct?
True. Yes, Your Honor.
So doesn't the statute necessarily involve the storage of, in security of the remains and respect for the remains?
I think it involves the storage, but there's nothing within the statute, and this court's decision in Carey is instructive, because the court said in Carey, look first to whether there's been any technical requirement or any provision of the statute that's been violated. There are many technical requirements pertaining to the donation process. If the commissioners wanted to institute technical requirements pertaining to the disposition, they could and should have done so. This statute's been around since 1968. It's gone through multiple revisions. When Massachusetts repealed the prior version and implicated and created the new one in 2012, not only did they not expand it, but they narrowed it. They narrowed it in two important ways. There once had been a statement that the institution must decently bury the body. That no longer exists. If the words decently bury were in there, Harvard would have a better argument that somehow we're alleging a violation of the UAGA, which we are not. And in addition to that, in the Section 18 immunity section, there's a sentence, as we've noted in our briefs, that relates to what may constitute prima facie evidence of good faith, and that is a donor card, among other things. It's within the context of Section 18, suggesting that this is what this pertains to.
But don't when you negotiate, even with the anatomical gift people, don't you have the ability to say, I want my relative buried properly, I want them cremated? Don't they? Isn't in that they can build that into the gift? Is that right?
Yes, they can. There is the instrument of anatomical gift allows the donor to determine how they want their body handled. Once, in accordance to the language in that instrument, it is no longer useful.
Right. So, I mean, if people can't set conditions for the, the treatment of their deceased relatives after the scientific work is done, they're not going to give their bodies for that purpose, are they? I mean, I don't quite see. I see there's clearly issues about how this was done afterwards, and the morgue managers behave reprehensibly, but I just don't see the argument that the whole process isn't covered by this. It just doesn't seem to encourage the purpose of the statute, as your fourth argument talks about.
Well, I think the purpose of the statute, Your Honor, is to ensure that the donation happens as efficiently as and effectively as it should. And that's all it articulates. That's all Carey says you should look at, the technical requirements.
It wants people to give. It believes that this kind of donation is incredibly important for transplants and science and training doctors in the future. So you want to encourage this.
Absolutely, Your Honor.
And the whole process encourages it if it's done properly and discourages it if it's done improperly, right?
Yes, and if it's done improperly, as was the case, admittedly, in this particular context of Harvard's morgue, it will have the effect of discouraging people from donating their bodies if there's no institutional accountability for that conduct. We would still have to prove negligence. Harvard's not strictly liable by not applying the immunity to this conduct when it is not specifically articulated anywhere in the statute. And again, Your Honor, I would strongly argue that that sentence rate disposition.
Can I get you to those two arguments then? Because you've got an argument about, and Carey provides for overruling this, right? Carey has language to the effect, I'm just looking at it, where it's pervasive, right? The conduct is pervasive. The negligence or the misconduct, whatever it is pervasive. And this is pervasive in respect to the morgue manager, but it doesn't seem to apply to any others. And let me compound the sentence one more thing. When you seek to hold Harvard liable, you use the vicarious liability standard, or at least the plaintiffs in the class action complaints. They all use that standard of vicarious liability, don't they? Every one of the causes of action directed at Harvard uses vicarious liability.
Because if we must allege vicarious liability, which we can then argue there is a vicarious liability argument applicability here, if necessary, under the Pettiford case, for one, which we submitted. The fact, we want to back up to say that if that's necessary, yes, but we don't believe it's necessary because no other court has looked at it. To the extent that you want to say something is outside the scope of that person's employment or not for the benefit of the employer, almost every instance of bad faith could be distinguished by the institution. And then you're left with, well, whose bad faith is necessary in order for it to be attributable to the institution? Is it the president of Harvard? Is it the board of trustees? Every institution is run by people. And every court that's looked at the bad or good faith of the institution looks to the people to determine if the institution, the only defendants in these cases, was or was not guilty of good or bad faith. And this court in the Prado case involving a peer review issue, where someone alleged, a doctor alleged that he was being discriminated against by someone on the peer review committee, looked to the individual on the peer review committee to determine if his conduct was good or bad faith, the only defendant being the hospital. But in the context of this immunity statute, it is the bad faith of Harvard, which is undeniable and admitted over many years, peculiar and persistent, which peculiarly persistent noncompliance, which Carey said could be indicative of bad faith.
When we read through your complaints, because there are a lot of them, we're going to find that you're trying to sue Harvard not through vicarious liability, in it both ways, that you're holding Harvard responsible for the morgue manager's actions regardless of vicarious liability. Is that what you're doing? Because when I was reading through the complaints, I saw each time you got to Harvard, you had a vicarious liability discussion. But I don't need to go that far?
Well, if the court were to determine that the statute applies, which of course we strongly say it does not, then yes, we would argue that the bad faith of Mr. Lodge, the morgue manager, was the bad faith of Harvard. However, if the court were to determine that the statute doesn't apply, then a vicarious liability argument would apply to his conduct.
And what cases, so I guess all the cases really involve one employee. It's usually, this is different in the sense of we have someone way out of bounds, right? And I understand one of the arguments you make in your brief is if we can't hold Harvard responsible for its, chief manager, how can we hold them responsible? Does he work for anybody else? Does he report to either of the other two people you're suing, or are they totally separate? The morgue manager, does he report to like the dean of Harvard's medical school? Who does he report to?
What we believe, based on what we know so far, is that he does report to the two supervisors, Mr. Cicchetti and Ms. Fay. Now, discovery would need to be borne to...
The anatomical gift person supervises the operation of the morgue?
Again, Your Honor, we're devoid of facts and discovery to determine the full extent of their involvement, but we do know that they were supervisors of Mr. Lodge.
So your argument is that they should have known? Based upon his ghoulish behavior and other factors, correct?
Well, there's certainly enough facts to plausibly suggest not only that they should have known, but they did know. And our complaint makes reference to the monitoring of the entrances that we argue did not take place appropriately. We have since learned from the summary report attached at the record appendix, page 658, that there were cameras in place, that there are key entry systems that validate that this is not a fishing expedition.
So they would have seen his quote-unquote customers come and go?
or had constructive knowledge of it. And if they had constructive knowledge and or seen it, then they ratified his conduct, which is undeniably bad faith on the part of Harvard.
So there's a director of security who sees the film, is that what we're to infer? I'm just trying to make sure I understand that. Because he's running the morgue, but you're saying the cameras, we don't know where the cameras go, right? Or from the allegations here, right?
From the allegations, no, but the summary report was attached, which was before the court at the motion to dismiss stage, and those cameras are at every entrance. So to the extent he was letting unauthorized strangers in, dragging body parts out of the morgue into his car in the parking lot with a license plate that said Grim Reaper, that's all information that we believe plausibly suggests that Harvard failed to act in good faith, meaning that they did not act in an honest belief that he was doing his job correctly, especially where he was suspended twice for reasons we don't know. And that's in our complaint as well.
Okay, thank you.
Thank you.
Attorney Murphy.
Thank you, Chief Justice Budd, Associate Justices, may it please the court. My name is Marty Murphy, and with my partner, Joan Lukey, we represent Harvard and the two current employees of Harvard Medical School, Mark Cicchetti and Tracy Fay, who have been named in 4 of the 12 complaints before the court. We urge the court to affirm Judge Salinger's decision dismissing all of the complaints against Harvard, against Mr. Cicchetti, and against Ms. Fay, because Judge Salinger correctly found that none of the allegations in any of the 12 complaints allege facts plausibly establishing that Harvard, Cicchetti, or Fay, as distinct from Cedric Lodge, did anything that was not protected by the immunity provision of the Anatomical Gift Act.
Could you address the argument? Okay, he's the director of the morgue.
His title was morgue manager, Your Honor.
Morgue manager. And if you can't hold the morgue manager, the only person in charge of this responsible, Harvard can never be held responsible. I'm just trying to, their argument is that the morgue manager always behaves in a way that is not completely in the client's, Harvard's interest. No one's going to be held responsible for this. I'm not sure I follow it, but they're saying we don't need to go through the vicarious liability analysis when we're dealing with a person like the morgue manager.
I think, Your Honor, the easiest answer to that is to point to a number of this court's cases about vicarious liability. Particularly, I think the easiest one to point to is the Purity Supreme case, where a store manager of a supermarket sent everyone else home and then sexually assaulted an employee of the store. He did it on Purity Supreme's property. He had the authority to send the person home. But the question that the court asked, and the question the court asks in all of its vicarious liabilities, is was this the kind of thing that the store manager was hired to do? Was he acting, at least in part, to serve Purity Supreme's interests? And in that case, the court said no to both of those questions, and that's the case with Cedric Lodge here. Cedric Lodge he had the title of morgue manager, but there's no allegation, no facts alleged in any of the complaints.
So a lot of what he does is clearly on Harvard's behalf, but the part we're dealing with, the criminal activity, you say is not. And when I haven't reread the Purity Supreme case, I take it the court just focused on the illegal conduct. It didn't look at the person as a whole, his level of control over other employees, the fact that he was the manager. They didn't do that.
Well, it did, Your Honor, in the sense that it noted that even though he had the authority to send the other employees home, the Purity Supreme could not be held vicariously liable because he was not acting to further Purity Supreme's interests.
I'm sorry, can you, thank you, Justice Kafka. Could you address on the 12B6 stage the allegation of bad faith that comes from the lax supervision and the warning signs that should have alerted the Harvard people that he was engaged in this behavior, or at least should have prompted an investigation?
Sure. Your Honor, the plaintiffs in the Superior Court essentially extracted all of the allegations that they said rose to the level of bad faith. And that's set out separately at, I believe, page 368 of the record appendix. It's 6 pages. It's all, we would suggest, conclusory allegations without facts. The closest they come, and they point out this in their appeals brief, is an allegation, which they say in their appeals brief, is that Lodge posted public photographs of himself on Facebook dressed up as an undertaker. I think if you look carefully at the complaint, that was on his wife's Facebook page. With respect to the license plate.
Yeah, we've got the license plate, we've got him taking duffel bags in and out, and we've got his customers, so to speak, coming in and out of the building. What about that?
All of those allegations, Your Honor, I would respectfully suggest could make out a case for negligent supervision. And to respond to Justice Kaffer's point, there are a number of the complaints that allege that Harvard and Ms. Fay and Mr. Cicchetti negligently supervised Mr. Lodge. But negligence under the statute is not enough, and under Carey is not enough to defeat good faith immunity. So all of the allegations, we say, amount at most to negligence and certainly do not amount to the kind of bad faith that Carey says is required, and the statute itself says is required to defeat good faith immunity in this instance.
Although the Carey standard, evidence of, I'm just quoting it, evidence of peculiarly pervasive noncompliance could warrant an inference that a defendant acted maliciously, blankety blank. Is the pervasive, I mean, this is not the first time a morgue has been subject to this kind of behavior, right? We have the UCLA incident in the past. You know, Harvard's on notice that you've got to monitor this, right? And then you've got, you know, do these two people, based on this complaint, do we know whether they're his supervisors or not? I mean, I just
Complaints that allege that they do supervise.
do supervise him. And what about the security video? Somebody at Harvard, and do we know whether this is after hours, or do we know anything about this security video from the record, about whether this is 10 o'clock at night or, you know, on a Saturday or anything like that? Something that will alert us?
No, Your Honor, there's nothing in the record to that effect. With respect to the statutory argument that was addressed earlier, I think it is clear, respectfully, that both the history of the statute, the text of the statute, the cases interpreting the statute, and the overall purpose of the statute make clear that this statute was designed to govern the entire process from start to finish. The statute, which was issued by the Uniform Commission on State Laws in 1968, initially was said to replace what they described as a confusing mixture of common law dating back to the 17th century with some statutes that had been enacted over time.
I get the overall purpose. Can I go back to their point? So if an employee or a manager acts somewhat negligently, the employer can be held responsible, right? Like most of those cases, we've got this nurse at a hospital asking for the body to be used for transplants, right? And whether she's going overboard. Here we've got someone, the more excessive they are, the less on the hook the employer is. There's something bothersome about that. Isn't there, again, Harvard could be held responsible if he's doing something minor, but Harvard's completely off the hook if he's doing something egregious. It's just, there's something bothersome about that. I just can't get my arms around it.
And I would respectfully challenge the first part of the court's assumption.
Okay, go ahead.
I think Harvard, if the employee acts negligently under the immunity statute, Harvard cannot be held liable if it only rises to the level of negligence. In the Perry case,
I get that part, but again, give the example of the nurse case. One of them, they're holding a hospital responsible because she's gone too far.
So in the Perry case, I think the court may be thinking of, and that's the case that the SJC and Carey cites for this pervasive noncompliance point. In Perry, the nurse knew that the procedure that was at issue there, which was, I think, a removal of eyes and corneas for eye transplants, knew that it was going to be an invasive procedure. She was acting within the scope of her responsibility by talking with the family about donation. But even though she knew that it was an invasive procedure, she falsely told the folks who she was dealing with, the family of the person who was dying, that it was a minimally invasive procedure. So there you have intentional conduct, bad faith conduct.
And you have
knowing
vicarious
conduct.
liability there.
And vicarious liability because she's doing exactly what the hospital and the organ donation organization caused her to do. The irony, if the court is suggesting there is one, is I think part of what is embedded in the 100-year-long principle of respondeat superior vicarious liability law in Massachusetts. In this court's relatively recent decision in Berry versus Commerce Insurance Company, that was the case involving a firearms instructor who drove his car at a high rate of speed and tried to spin it toward other police officers and ended up actually causing serious injury. This court noted that under the restatement principles, the farther afield, the more outrageous a individual's act is, the less likely it is to be viewed within the scope of employment.
I get that, but does this act we're dealing with here, by letting the employer off the hook completely, run into sort of conflicting with the intentions of the legislature when they did this? That's what I worry about, is that if the only person you can hold responsible is going to be this probably, judgment-proof defendant, is this going to produce the result the legislature wanted, which is people willing to give their deceased relatives' bodies to science because they're not going to have the comfort? I think this is what Mr. Catalano was saying, that those bodies will be protected all the way through the process. How do we reassure that's what the legislature intended here?
I think, Your Honor, the legislature intended two things, and I think it's made clear in Carey and made clear in the initial enabling language. They intended not only to encourage the giving of anatomical gifts, but they intended to clear the way for institutions to receive anatomical gifts.
I get all of that, and that's why I think you're probably right on the first part. But what I don't get is how, when it gets so egregious, you can't hold anyone responsible except for, this one judgment-proof type actor. That's what gnaws at me. I don't know if I don't know if there's no way to round it, but it does seem problematic at the end of the day that the institution that got the body and benefited from it and furthered science is not responsible for the actions of its manager.
I would say, Your Honor, that in any case, whether it's a judicially created immunity, like judicial immunity, or immunity applies to examiners and SDP cases, or it's statutory immunity, the grant of immunity that either the legislature or the judicial doctrine creates always raises the bar and makes it harder, sometimes impossible, for a plaintiff to recover. But that reflects a legislative judgment balancing the importance of the protecting the rights of plaintiffs to recover against, on the other hand, the important interests that are protected by clearing the way and making, in the language of the initial drafters of the Act, allowing institutions like Harvard Medical School to accept these donations without even the, quote, fear of legal proceedings. So I think that's really how I would answer the court's the court's question. I think, Your Honor, the language in Carey that Mr. Catalano pointed to about violations may be worth noting briefly here. In the Carey case, the court used a number of different formulations to take account of whether or not the Uniform Anatomical Gift Act addressed what was going on here. They said, does the Anatomical Gift Act authorize something? Does it, was there a technical violation? Was there a technical violation of a requirement? Was there simply a violation of a requirement? Did the conduct adhere to the Anatomical Gift Act? And I think if the court looks at what is alleged here, we've cited a number of provisions that make clear that this was designed to govern the entire process from the beginning to the end. 11A1, which authorizes medical schools to accept institutions for, accept donations for research or education. Here, clearly, the uses were not limited to those purposes if the allegations of the complaint are taken as true. Similarly, with respect to the language in Section 14H that was discussed earlier, it covers the actions after donation. And we point the court to the Scarborough case, in which the plaintiffs alleged, similar to the plaintiffs here, that the immunity statute didn't attach to acts after the transactional aspects of the gift. In Scarborough, which is a case from the Court of Appeals in Maryland, which is really the only other case addressing the issue directly, the court rejected that claim here, really for the same reasons that we've argued. And I think in the brief time I have here, I think with respect to that question of whether the language in 14H, whether Section 14 applies to medical schools at all. The title is Organ Donation Procurement Organizations and Others, and there are specific sections that address organ procurements or organizations, 14A, 14B, 14C, 14G, but there are others that are addressed broadly to persons. And those provisions include references to, by definition under the statute, to Harvard Medical School. And the specific language that we cite in 14H is directly addressing the donation of whole bodies. We respectfully request that the court affirm Judge Salinger's decision.